Try not to become a man of success, but rather try to become a man of value. Albert Einstein. A very bright morning. On behalf of the Postgraduate and Research Department of Commerce, Ethiraj College for Women, I welcome you all to the webinar titled Intellectual Property Rights for Novice. We are extremely honored to have Dr. S.T. Deepa with us. Now, I request Ms. R. Akshaya to deliver the welcome address.
Thank you, Zulfit. Good morning to one and all present here. Today, we have with us Dr. S.T. Deepa, an academic professor with an established following and an in-depth knowledge in computer science domain. She is currently working as an associate professor of computer science and research director since June 2020. Ma'am has an expertise of 19 plus years in handling all the major subjects of BSc and MSc Computer Science, BCA and MCA, MPhil Computer Science, and allied subjects of MCOM. Ma'am has also been the Assistant Chief Superintendent during the academic year 2010-11, Chief Invigilator for TNPSC VAO exam 2011, the ISO Management Representative, and was the editor of the peer-reviewed journal Knowledge Economy from September 2014 to May 2017. She has been awarded with the Sangamam Inspiration Award 2020 from Sangamam Global Academy, Pondicherry in the year 2021. Ma'am has published several books and journals, which include Object Oriented Analysis and Design, Client Server Computing, Diabetic Detection Using Neural Network, to name a few. She is a life member of Computer Society of India and Indian Society of Technical Education. Ma'am has presented papers in various conferences and seminars. She was invited as the chief guest and delivered keynote address in the National Conference on Recent Developments in Smart Technology conducted by Prince Sri Venkateshwara Arts and Science College, Chennai, and has also presented a live show, Dial Jaya TV, on computer education on Jaya TV in August 2007 and answered the public queries. We're delighted to have her with us today. Now, I request Dr. S.T. Deepa to take over the session.
Good morning to one and all present here. I'm really happy and honored to be a person to share my thoughts on intellectual property right. To begin with, let me tell that I am not a person, being an associate professor for 20 years, I am not actually a pioneer in intellectual property right, but I have started my journey working on IPR probably 3 or 4 years before, so that I started learning what is IPR and how it was helpful for me as an academician, and how the thought process differs when we started thinking about our intellectual property right. Okay, this is very short information which I just want to share. Just because I'm giving a lecture, I am definitely not a pioneer in IPR. I have learned few, and as a professor, I am really delighted to share my thoughts on IPR to you students. And I'm happy that you to IPR at the early stage where you are doing your undergraduation or post graduation. We are not blessed so, because only at the probably a 5 or 4 years before we started thinking what is IPR, and how can I protect my content, may it be a book or my journal publication. How can I protect my content? Okay, all these thoughts came up to us very recently, but you are really blessed to have exposed to this topic early in your academic career, so that whatever you try to create, you can always have a IP for it. Ma'am, can I have a slides on, ma'am? Okay, so this is just an introduction slide, and we are going to talk about what is IPR, what are the different types of IPR, and so, ma'am, the next slide, please. Okay, so this is what we are going to see. This is the broad points that we are going to discuss today. Um, sorry for the sore throat. So these are the points which we are going to discuss. The first one, what is IPR and what are the types of IPR? Probably I understand PG students may be aware of it. If it can be a different definition for you. The next one is what is a patent and how can I get a patent? What is the claim in the patent, and how should I represent my creative thing to the IPO office? Okay, so those things are what we are going to see, and we are going to have just an introduction about what is patent attorney, and probably I will brief on how we ourselves can become a patent attorney. It is again a new venture for any commerce fair students to look into as a career opportunity. Okay, ma'am. The next slide, please. Okay, so first of all, what is an invention? Uh, uh, Invention is nothing but which is never made before. It doesn't mean that it doesn't exist. It would have been existing, but it is not known to the world. Okay, so it is something that has never been made before, or it can be a process where which creating something that has never been made before. So invention is what everybody was interested in, and we feel that only great people, scientists, can do an invention. But when it comes to IP, next slide, ma'am. When it comes to IP, it is actually an intellectual property right. Okay, so this is a general definition of intellectual property. So, according to me, intellectual property is
We have a technical glitch in the speaker side. Let us wait for a few minutes.
sorry. The thing is like, when we were talking about IP is nothing but a term which refers to the brand invention. As I was discussing earlier, anything which is very creative is IP. Okay, so you youngsters are really very good and creative in creating a mime. If it is your pure full thought is yours, then you can even copyright that particular mime or your design. I know you people, you draw mandala art, you design your own attire. So all these things are intellectual property which can be filed under IPR. So usually any business people for that matter will have at least two or three IP for their business. Next slide, ma'am. Okay, so what are the different types of IPR? Generally, there are almost seven types of IPR, but we concentrate more on patent. That is one of the disadvantage of us, because we are not aware of what are the different types of IPR and what are the things which I can register under IP. So these information will make us understand that even a simple creative thing which we do can be registered under IP. So the different types of IPR includes copyright, patent, trademarks, geographical indications, industrial design, layout design, plant variety protection. So let me brief few things here, and we have different slides explaining each and everything. Plant and variety protection is I can have any possible ways by which I can protect a plant variety or protect an animal variety. So if I have a procedure to do it, I can register that procedure as an IP. Or else if I have a layout which is nothing but a blueprint of your house which is innovative and designed by you can copyright that or you can register that IP also. The next one is industrial design. Industrial design, we will see those things in detail. And copyright and patent are two things which anybody can work on. Say, for example, you are a person, a PG student can write an article, and that article can be copywritten by the IPR. Okay, by in that way, and it is to make sure that things are yours. So you can always give in permission to them, but the permission is only with you others cannot use your data without your prior information. Next slide, ma'am. Okay, so first thing is copyright. I am going to concentrate more on patent, what is a claim, and all those things. But as an academician, one important thing that we should also know, as well as the students, because you interact with the faculty members, you will have a mentor where you can work along with and have a paper presentation, or you can have a small questionnaire and get an analysis out of it. You can even create a SEM model out of it. You can suggest a model for long absentees to your institution. So these are the basic literature things which can be copywritten. So when I say a copyright is actually a form of protection which is provided to the authors of original work of authorship. So what are the things that comes under copyright? Your literature publications, all your dramatic videos, your musical compositions, artistic informations like your drawing, your design of any product, or any intellectual work. Okay, so what is the duration of your copyright is? It is the life of the author plus 70 years. So it is almost two to three generations. Okay, so we can look into this copyright.goe for details. uh, we will look into few websites now. Ma'am, next slide, ma'am. Okay, the next one is trademark. This is more for the business people because they have to have their own trademarks for their logo, their design, the name of the business concern. So those things are the trademarks. Even the smell of that particular product can be made as a trademark. Okay, so when I talk about trademark, it can be anything with a word, a name, or a symbol, or it is actually can be a combination of the name and the word. For it is mostly used in the commerce field to identify and distinguish between goods or services. So we have seen lot of examples. See, Adidas is actually one of the well known footwear product, but if you see, there are a lot of bags where Adidas is something like Abidas, only the second D is changed to B. So to avoid all those duplicate versions or first copy versions, I can always have a trademark. See, now even today we have first copy, or we call it as a master copy products, where the product as such is sold at the rate of around 15,000, 20,000, whereas I can get the master copy or the first copy of the same product for 1,500 rupees or so. Okay, but how can we make out the difference between both? May it be a first copy or the original? The trademarks plays its role. So the duration of the trademark is 10 years, and I can again renew it for a 10 for the next 10 years. So what are the different types of okay, ma'am, the next slide after trademark. The next one is trade secret. Trade secret is something like a unique combination of information which is maintained for that business. The well-known example of trade secret is your KFC. Any herbs which is used in KFC products is not known to the world. Okay, so that is the reason why KFC has gained its popularity. Okay, so what are the trade secrets? The trade secrets can be a formula, it can be a pattern, it can be a program or a device, or it can be a process. Okay, it can be a hierarchy of process in which the particular ingredient has to be put inside the particular product. Okay, so what is the duration of this trade secret is, it remains as long as it is a secret, then I can maintain the trade secret. So if you remember, it's been years that KFC has come up with the product, but it is still a secret because they maintain it confidentially. That is the trade secret. So these are the different types of types of IPR which we can think of. So the best known Indian example is your different masalas, or talapakatti biryani is one of the trade secret, because people are not aware of what are the ingredients that they use in preparing their biryani. Next slide, please, ma'am. Okay, so patent, as we all know, I think patent is one IP which is known to many. Though there are a lot of different types of IPR, patent is one thing which is known to everybody. So patent is actually a model or a process. It should be a product or a process, so that it should have a technical information, and it should have a public use. Okay, so it can be a solution to the people who are working. When you go through the examples of patent, there are a lot of things which comes under patent. Even no, you would all have seen the recent flip model of Apple iPhone. If you see the history of Apple iPhone, which is a flip model, it's been almost 7 8 years. It's been registered in US patent office that the Apple is going to come up with the flip model. But they are going to try only in Apple 14 or 15. Okay, so this is how other countries are uh, really ahead enough of registering and using the patent. We people are trying to develop the model and register it, whereas those people have a prototype of it, register it, then do a complete research on the product and bring it to the market. Okay, so patent, the duration of the patent is 20 years. The next thing what we are going to see is, and the next slide, ma'am. So the next thing what we are going to sorry, the next thing what we are going to see is utility. Utility model is actually defined as a small. It is not innovative enough to merit the protection affordable to the invention. Let me explain this in a very simple word. It is something like, I have created a ball, okay, which is a cricket ball. Okay, so so far, if everybody knows that this ball is used to play the game cricket. Okay, so if I do, and I am just modifying it a little bit and making it to use for playing, then that is called the utility. Okay, utility model is nothing but the existing thing. I do a little change and I say that it has another purpose also. That is the utility model. Okay, the another example is like, you can have we are having a different version of TV. Okay, so can patent it, but any advancement on it, the base is the same. I am going to change, just add one new thing, then that becomes the utility model. Ma'am, next one, ma'am. The next thing what we are going to see is industrial design. Design, we I'm not going to have a working model of it. I am going to just design. I can say that the the motor of a particular system should be like this. I can say that the CRT, that is the cathode ray tube of a television, should be designed like this. If I say only the design of it, whether if I am not going to give any working model for it, then I call it as a industrial design. So I should have a shape for it. I should have a pattern for it, and if needed, I can have a real design. Ma'am, next slide, ma'am, please. The next is your geographical indication. The best example of geographical indication is your Kanjipuram Pattu. So when I say Pattu sari, all of a sudden you will remember, Tamilians immediately remember your Kanjipuram. When I say Malligepu or jasmine flower, you immediately remember Madurai. This is the geographical indication. So there is some speciality maybe that may not be known to the people there also. but there is some specialty for that particular geographical location. So they can always register their information. Say there is a farmer in Madurai who cultivates jasmine flower. He can register the geographical indication there, so that nobody else can take that particular jasmine flower and use it without his knowledge. That is the geographical indication. Different types of IPR. Okay, IPR is not only a patent. Okay, it is a patent. It is a design. It can be an industrial design. It can be a geographical indication. It can be copyright. It can be trademark, or it can be trade secrets. It is so open that we can always look into having one IP for ourselves. Ma'am, next slide. Okay, the next thing what we are going to see is prior art search. Okay, so what is prior art search? See, we are telling that whatever you think or whatever you feel creative, you can be registered under IPR, but it should be unique. For then you should know whether this particular information or this particular design or this particular geographical location is available elsewhere in India. So that is the particular
Sorry for the inconvenience. There is a technical glitch in the speaker side, so let us wait for a few minutes.
Oh, sorry for the technical glitches. We have constructions going on, so the network is unstable here. So, what is prior art search? See, we have decided that we are going to create a new product. I should know whether this product is available elsewhere in the world or not. Again, before getting into this prior art search, I would like to insist that the IPR what we are developing is, again, I have a geographical constraint. Say for example, geographical constraint, by that I mean, if I am a person who is going to register my IP in India, the same product may be available in US, not in India. So I have every right to register in India with slight modification. So you have but that is not a good practice. Though there is a geographical problem, geographical location where I can consider submitting my data in IP, it is always better we look into all the prior art search. We look into all the patent office and register our content in the appropriate patent office. So I, as an Indian, can register my information in US also, or I can register in Canada, I can register in Germany, I can register in Australia. The process is same, but every country has their own way of addressing the particular product. Okay, so that is the, see here in Australia, they consider your utilitarian patent as an innovative patent. Okay, here this utility design cannot be considered as a patent. It is considered only as a utility design. So this is the different name given to the same thing, whereas the same thing can be applied as innovative patent in Australian government. Okay, so we should first of all know whether the data which I have created, or whether the product which I have created, a design which I have created, whether it is already available or not. Okay, so for that process I have to meticulously do the prior art search. As the name implies, it is a search which has to be done prior to filing our information. Okay, so a prior art search will uncover any knowledge existing prior to the invention at hand. This knowledge might include, but not limited to, patent application, scientific thesis, and industrial know-how. One of this knowledge is obtained, an inventor will get an accurate idea of how novel and obvious, non-obvious the invention is. So this is very important, because when I file my IP and if somebody else opposes it, all our work is in vain. So before somebody opposes it, if I would have done a prior art search, exhaustive prior art search, and then filed my data, the possibility of opposition is less. Next slide, ma'am. Okay, so how can I go for the prior art search? I can do it in Google Scholar with short listing of keywords. See, first of all, when I have to create a IP, I can always have a broad classification. Say, for example, if it is in meant for medical industry, so medical industry is a broad category. So I shall start searching on medical industry first. Then I can get into individual. See, inside medical industry, I can go for cardiology. Then inside cardiology, I can think whether it is bypass surgery or like that. So we can start the search in a broader way. Then I can narrow down. It is something like we start as with generalization, then I get into the specific part, which is a specialization, which we call it as top down approach. And there are a lot of websites where you can search whether the data or whether your invention is already done or not. So we have a lot of databases available. We can have an exhaustive internet based search, and we can have an analysis and interpretation of the results which we have gained, and then come to a conclusion to which country, how am I going to my IP. Next slide, ma'am. So if there are the next slide, I have given free, a few free patent databases. There are databases which is paid also. So the best thing is I can go for Google patent. Ma'am, is there any possibility that you can click on that link and go to the website, ma'am? Okay, so these are the few patent databases which can be looked into for us to identify whether the data which we are going to present is available or not. Okay, WIPO, WIPO is one of the it is a world patent office which has a lot of database where we can look into whether our invention is being done or not. Okay, so then we will look into the so you can, ma'am, it is not so visible to us. You can just get into the slide again, ma'am. The interested students can just browse through the link which is given. I think the department will share the PPT with you. You can just browse through it and find how to do a prior art search. It is very much similar to your literature review. While you are writing a program, or whether you are while you are developing a paper, writing a paper, research paper, we usually do uh, a literature review. So that is more on academic side, whereas your prior art search is more on your technical and innovation side. So if you know, when I am going to do a literature review, I get into certain academic database like Sodh Ganga, Sodh Sarita, so those things, certain journals. We look into Scopus, we look into web websites. Similarly, for patent and IPR, we can look into the websites, databases, which is just shown in the presentation, and we can identify whether the invention which we are trying to do is available or not. Ma'am, next slide, ma'am. So, so far what we have seen is what is an invention, or what is an industrial design, or what is a patent. But what not is an invention is also the information which we should know, because next slide, ma'am. Because while applying, it is important that I should know what I should not do also. Okay, so anything which is contrary to your natural law, I cannot present as an IP. Or if it is exploitation to the society and the mother earth, I cannot apply to as an IP. So, and I cannot, when it comes to invention, it should be a working model. I cannot not just submit the scientific principle, or again, I cannot add few futures into it and apply for invention. Okay, so those things comes under industrial design and utility design. It is not an invention. We have a list, almost 20-25 list of information which should not be considered as invention, but want of time, I have included only four, because these are the certain things which immediately comes to our mind. So anything against the natural law, I cannot register for invention. Anything which is harm animal kingdom, I cannot register for the invention, register that as an invention. Just a scientific principle or an abstract formulae cannot be applied for invention. And adding few information to increase the efficiency of the product, that information cannot be considered as an invention. The next thing, ma'am, next slide please. So let me introduce few things about Indian Patent Act. So Indian Patent Act was actually done by the Patent Act people in 1970s. Okay, so we Indians are really ahead of every other part of the globe when it comes to the logical thinking and all those things. What we failed was registering our knowledge as a patent, or as a design, or as a copyright. Okay, so there are few advantages of Indian Patent Act, or certain features of Indian Patent Act. Okay, So I can register either a product or a process. Okay, product is as a working product, or I can say these are the steps for that particular product. Both is all possible when it comes to Indian Patent Act. The next one is the term of the patent, which everybody now is aware of. The term of the patent is 20 years. And the next thing is we can always have an examination on request, which means I can always speed up the process. So I can file my IP by getting myself into the website of Indian Patent Office, IPTO. And now it accepts the online application also. Initially, before pandemic, it was only offline application, which is a physical submission of application, whereas now even offline application is allowed. And I can always ask for fast publication. Okay, let me tell the process in short. When I say I have found one thing, I will first register my. See, usually any patent attorney will guide you to register your idea first, because the first to file is the first to get the right. Okay, so always that is the reason people will say, when you have a thought and you have a plan of registering as patent, first register, then discuss with others. Because once register, somebody, even if somebody else come and register the same information, you can always claim that it is yours because you have registered the idea first. So once the idea is registered, the patent office will be giving us 18 months, which is 1.5 years, to create a working model and submit. Okay, so that is the one of the advantage of your Indian Patent Act. And we have a pre-grant opposition and post-grant opposition. So what is pre-grant opposition is, I am filing my IP, and that will be published in the Indian Patent Journal. So there is a journal which is exclusively meant for Indian patent. Okay, the paper will be the abstract or a design or a drawing which you have designed will be published there. And the Indian Patent Office will wait for 80 months to understand whether there is any opposition or not. It will wait whether there is any opposition or not. So if somebody else oppose, I can always say that the person who is opposing may be wrong, because these are the extra features that I have included into my idea. It can even be the post grant opposition, which is where if it is a post grant opposition, it will become a civil uh, case. Okay, so that is one of the characteristics of Indian Patent Act. The next one is, I can ask for fast track mechanism. It is again left to the inventor. I can ask for fast track mechanism. If I am confident that my working model is will be ready within 6 months, I can ask for fast track mechanism, where the entire process will be speed up, and I will get the grant early. Okay, and this will sustainably and will reduce the time needed for the patent application. One advantage of patent is, see, if we are writing a paper, we say that the first author 70% of the loyalty, second author 30%. It is not only royalty but also sorry, it is not only royalty, it can even be, if it is a knack score, 70% go to first author, whereas 30% goes to second and the third author. But patent, all the authors, I may be the first inventor or and maybe a seventh inventor, everybody has equal right on that particular product. That is one of the advantage of your patent. Next slide, ma'am. So the next one is, what are the documents which we require for the application or filing the application. The first one is duly filled application form. Uh, it should be in duplicate. So in that I mean that we have filed the same thing in other countries also. So there is a form 3 which has to be filled to make the Indian Patent Office understand that I have applied for other country also. And what is the proof of right to apply? So this comes when I am approaching a patent attorney to apply on my behalf. Okay, so I will discuss about the patent attorney in detail shortly. So if somebody else is going to work for me, work in the sense somebody else is going to write the claim and apply on my behalf, I will be giving the proof of right to apply. And I have to give this patent specification. I should have an abstract. Initial, your idea should have an abstract. If there is any drawing, I have to submit the drawing also, and the power of authority should be given to the patent attorney. So these are the basic documents which is needed when I am going to submit my idea, file my idea. It is not a working model. Very initial stage, I am going to submit just my idea. I will say that this is how my model will be. It is better that I just submit my document of drawing alone with the 150 words of abstract. Next slide, ma'am. Okay. So the next important thing is patent claim. Okay. So when I say a patent, I should claim what I am going to apply for. Say, for example, you are going to apply for patent of a safety pin. You see, there is just a circle or a wind of the particular pin. You have to say in which diameter, what is the diameter of the wind up of the pin. So those details has to be specified. If there is a slight deviation, you can always sue a person who is using your product. Your jump clip, if it is no, we wonder, your jump clip, your push pins, everything is patented. So if you change the patent of the push pin, only the person who was got the uh, patent right can do it. Okay, so claim is very important. So you have to specify each and every information of the product which we are going to develop. Okay, the patent claim can be two things. One is independent claim and dependent claim. Next slide, please, ma'am. Okay, so as the name implies, independent claim is not dependent on anything. Okay, whereas dependent claim is dependent on the independent claim. Very simple. You take a steering of a car. If I am going to give a product as a steering, then that is an independent claim. So how will I claim? I will have a circular product which can be used in car, which is stated as this is the diameter of the circle, and inside that you will have three things, and there will be a speedometer and everything. So so I have to give the details of each and every element which is attached to that steering. Okay, so that is the claim we have to make while I am giving a product. Okay, if the Apple has registered for the flip model, it has to specify the size of the flip model and how it will flip, whether it will flip horizontally or vertically. So even those information has to be specified in the claim. To our surprise, there were days where even the ballpoint pen refill has been registered as patent in US Patent Office. Next slide, ma'am. So the next thing is about your abstract. The abstract, as we all know, is summary of what am I going to present, or what am I going to. It should always have the details of the product. Okay, but the claim will say the each and every specific details of the product. Okay, so the abstract should be of it can be abstract, will be available for all the models, may it be your geographic indication, may it be your business industrial design, your utility model, everything will have an abstract. So the next one is patent right. So if I have registered, ma'am, the next slide. If I have registered for patent, what are the rights I as an author or I as a patentee is can do? Okay, the first thing is I can license it and sell the product for commercial. This WhatsApp is taken up by Facebook. It's just I am selling my patent to the other business concern. Okay, so that that is one of the right the patentee can do it. If there is somebody else who is going to use it without my knowledge, I can always have a legal proceeding against that particular person. I can use my data for my commercial purpose also. So in general, it is mine. I can do whatever. It should not affect your anyone in the world or the plant and animal kingdom. Okay, that is one basic thing which we have already seen. But other than that, it is my product. If I want to sell it, keep it. The choice is mine. Next slide, ma'am. So what are the patentable criteria? We have seen this. There are three main criteria which is needed for a patent. First thing is novelty. It should not be published in India or anywhere else. Okay, before filing it in India. That is the reason we have to specify. If I have filed in some other country, it is something like an academician applying for 2-3 journals. Whichever comes up first, I will say no to the other journal people. Okay, so I should specify that I have applied in other countries also. Okay, it should have an inventive step which is not obvious to the person. Okay, directly seeing the product, I cannot say that this is what has done it. That is the inventive purpose. The next one is the patent should always have a industrial application. So that is the reason the patent will always be given to a working model. As far as India is concerned, the patent is given only to the working model. Others have their own thing. If I have to publish, I have to register my paper. Trademark. If I say patent, it should be a working model. So anything which is novel, which has an inventive step and which is applicable in industry is eligible to be patented. Next, slide is all about your patent attorney. The patent attorney is a person who is eligible, who has undergone a course and a specialized person. He is a pioneer or expertise in writing the claims, applying for the patent, all those informations. That is the patent attorney. So as we, for an auditor to write a CA exam and all those things, patent have their own way, or there is an exam for becoming a patent attorney. Okay, usually lawyers who have done BL will go into patent exam, but commerce students can also try writing patent. It is all, say you study industrial law, you study your commercial law, similarly you have a list of laws for patent which you should be aware of, and your communication skills should be good enough to write a claim which convince the patent office people. You can easily clear the exam. So being a patent attorney is one of the career opportunity for commerce people. When it comes to patent paper, to start with, if there is anybody, any students, UG or PG students, who are really interested in have a touch and feel of how a patent content or how the patent subject will be, NPTEL has come up with few courses on patent. We have a domain certification exclusively for patent also, so you can start it doing beginners, that is done by Dr. Feroz Ali of IIT Madras. So he has have come up with a few one two or three courses on patent in NPTEL. The basic thing is patent drafting for beginners. We have patent for lawyers and scientists. We have a patent for engineers also. Okay, so these are few papers. If at all you want to understand how it will be, how the different terms will be there in such course. I think the January window is open now. Dr. Feroz Ali Khan has done one paper, I mean, course which is patent for lawyers and scientists. Last slide, ma'am, which is IPR for academia. So, being an person, academicians, probably students can be an entrepreneur, can look into a trademark, can look into trade secrets in future. But currently we can work on copyrights, because being an academician you would have written a small storybook. You can even have a book on your mandala art. That book can be copywritten. Your small being a commerce students, you would have been doing a small research analysis, having a questionnaire and coming up with very small findings that can be published and that can be copywritten. So these are few things which I thought I can share with you all. As I have told earlier, it is not that I am a pioneer in IPR. I have also started learning it, and even now I am learning on how to look into patent and all those things. Thank you so much for the information and the time you have spent with me. I think it's almost 45 minutes that you are with me. Thank you so much, and I would like to conclude my speech with one of the best quote of Shivkara: winners don't do different things, they do things differently. So it is all how you start, when you start, how much ahead you are with other your colleagues or your peers. All that matters for your success. Thank you so much, and the session is open for the questions.
Thank you very much, ma'am, for that informative session on IPR. Shall we move on to the Q&A session, ma'am?
Yes, ma'am.
First question is, in cases where word like Xerox, a brand of photocopying was generalized by the public, what will be the use of trademark then?
Ma'am, these things can happen in our country, but this cannot happen in other countries, because as we all know that we, even the systems which we use is pirated version. Okay, the softwares which we, but that cannot be done in other countries. Even the Apple iPhone which you use, you cannot use pirated versions. Okay, it is all on the Indian context. The use of trademark matters a lot in other countries. It is all the information which we get. So if my content is used by others, how many of us know that I can sue a case against the person? So people has to be aware of what should be done if there is some infringement happening. Okay, there is a news more than anything. I am not aware that my data is exploited. If I am aware that the data is exploited, I have every right to file a legal case against the person who is using it.
Thank you, ma'am. That was a fabulous answer. Next question. What is the advantage of a trademark when the competitors can trick the minds of people with similar spelling with one or two letters missing? Example, Adidas copied as Adidas, Reebok copied as Reebok.
That's right. What you are trying to tell is right, but you are intelligent enough to find that it doesn't master copy, right? So that awareness, we as an academician, we as a commerce students, has to give to the society. So it is our responsibility to do it. See, very simple. See, there is a master copy of Apple AirPod we have. Actually, the AirPod costs 15,000 rupees, but there is a master copy which is on open market, which costs around 1,500 rupees. Okay, so if we, yeah, it is all about the integrity of the individual at an individual level and at the society level to decide whether to encourage those people or not. Okay, so as in people who are really educated enough, and who are exposed to these kind of informations, it is our responsibility to educate our family first and the surroundings, so that at one point in time the entire nation will understand to avoid the different versions.
Okay, ma'am. That was a thoughtful answer. Next question. How will being a part of international institutions like WTO may affect some developing countries at times, like recently India being accused for sugar subsidy by other countries like Brazil and Australia?
Ma'am, being having been the globalization, privatization, the developing countries has all options to grow and come up with the informations, ma'am. Now, it is not that India, developing countries are affected. In fact, the developing countries or the countries which is given concern by WTO for their development. Okay, because they want the countries to develop, because there are a lot of resources in developing countries. In developed countries, they have only one resource, like oil refinery, something like that. So they are developed because of only one resource. Whereas we developing countries have lot of resources, including a very good human resource, which is exposed to communication skill, which is exposed to social skills. So it is not that developing countries will be affected. It is all a path of struggle that we have to undergo. No path is a path of roses. It is a struggle that we have to undergo to come up as a developed country.
Thank you, ma'am. That was an informative answer. Next question. Why is compulsory licensing is not applicable to trademarks?
It is actually a management government level decision which has to be done. So if it is from the top, it should be a top down approach. It should be implemented from the government, so that there is no possibility of entering into loopholes. Okay, if there is a loophole, the human mind is really intuitive to enter into the loopholes. So it is the administration which should make sure that there is no loopholes and the entire nation follows the rules and norms. Think of a person. I think you all may be driving two wheelers. How many of you stop when you see an orange yellow light? your mind immediately stay. You have another 1 second to go, just run through, cross the road. How many of you stop when it is red light is there, stop light is there, though there is no traffic police and you're on the way to your college? So one thing is individual. The second thing is like, you should have a rules. Though there is a rules, we should try to implement that. That is our responsibility as.
Yes, ma'am. Thank you, ma'am. Next question. Why the patents are given a limiting period, though it is one's own creation?
Ma'am, I think it is the lawmakers who have done it. And as far as my knowledge is concerned, most of the patents are technical information. So probably in another 20 years of time, 2 decades is a longer period for any technology to become obsolete. How many
Thank
of
you,
you are
ma'am.
using floppy disk now? Nobody is using. How many of you are using Nokia phone now?
Nobody is
So
using,
any
ma'am.
creation, I think it is a circle. So they have thought of it wisely, so that 20 years is actually a longer period.
Thank you, ma'am. That was a fabulous answer. Next question. What is the difference between data protection and IP rights?
Ma'am, data protection is not at all legal, whereas IP right is. See, if my data is used by you, I cannot do anything. I can just see. Probably I can ask you why you have done it. But IP is entirely different. If I know that you are using my IP, I can sue a case against you. So that is legal aspect is the difference between your regular data protection and IP.
Thank you, ma'am. That was the last question. Thank you, ma'am, for sharing valuable inputs. I now call upon Ms. Shukashini Jayakumar to propose vote of thanks.
Thank you, Ms. Zulfit. It is my deepest pleasure to propose the vote of thanks. First and foremost, I thank God Almighty for making this day possible for us. I take this opportunity to thank our speaker, respected Deepa ma'am, for agreeing to be the speaker for this session and a talk that evoked deep knowledge and clear insights on IPR. I'm sure my fellow students would have immensely benefited from the information you have shared, and we will surely make the most out of it. Thank you, ma'am. I thank our chairperson, Tirumati Chandra Devi Tanikachalam, Principal Dr. S. Kodai, and Principal in charge Dr. D.B. Usharani and Dr. T. Usha Priya, Vice Principal Self-Supporting, for their encouragement in all our endeavors. I thank my beloved HODs, Dr. A.S. Saranya, Aided, Ms. Geeta Krishnan, Self-Supporting, and all our faculty members for guiding us and making this day a successful one. I'd like to thank my friends, Ms. Zulfit, Ms. Akshaya, and Ms. Sri Lakshmi CB for your cooperation and sincere support. I extend my heartfelt thanks to everyone for your presence and active participation. Thank you all once again.
Thank you very much, Sukashini. The feedback link will be posted in the chat box. Kindly fill the same. Thank you all once again and stay tuned for the upcoming sessions. Have a great day. Thank you.